How do we introduce evidence in court? My name is Carl Birkhead. I'm an attorney with Wirth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for about 7 years now, and I want to help you make law easy by talking a little bit about when and how to introduce evidence and use it during the course of your trial. Um, this is your lawyer is going to do most of the work in these situations. So the evidence introduction part is kind of the part where the client can kind of sit back, rest a little bit easier, and let their attorney go through the steps of, laying the foundational questions in order to introduce the exhibits into evidence. But you do still have a part to play. So let's say, for example, you wanted me to use some screenshots that you thought were relevant to your case. And I agreed. And I think that we're at a point in the trial where those screenshots can be used. I'm going to take a copy of those screenshots. I'm going to hand them to you. I'm going to say, Mr. Smith, can you tell me what I've just handed you? You'll say, yes. These are the screenshots that I took of this conversation that I took with the blah, blah, blah. And I'll say, okay, did you previously provide these screenshots to my office? And you'll say, why, yes, I did. Thank you for asking. And I will say, okay, now I want you to go through these and I want you to read through them, just briefly. Let me know, have these been altered in any material way from the time that you took them? And you will say, no, these are exactly as they were whenever this happened. These messages are in the condition that they were in. Nothing's been done. Nothing's been changed. These are them. And then I will say, Mrs. Your Honor, or Mr. Your Honor, I move to enter these exhibits. And then we're going to start talking about them. Now, that doesn't mean that I'm going to want you to just go through and read every single line of those screenshots into the record. You don't need to do that. That's why we've admitted them as exhibits. In the almost 7.5 years that I've been practicing, exactly one time have I had to have a client read every single line of an exhibit into the record. And that's because the opposing counsel objected to them being admitted, even though they could have been, because he claimed that he hadn't seen them before. Now, as an aside, he had. But rather than get into a back and forth about when and how they were produced, I just had my client read them instead. And I can honestly tell you, the opposing counsel regretted having objected, because instead of them just being admitted and the judge hopefully just skimming through them instead of looking closely, the judge heard every line of these bank statements that were admitted, showing all of these deposits that had been made into this gentleman's account, which really undercut his assertion that he couldn't be paying alimony at the time, when over the course of 6 months we were able to read in $75,000 worth of deposits. This is the part of litigation that's kind of fun for attorneys, though, because we get to use these exhibits however we can and however we want to help make you look great and the other side look less so. So let us have fun with it, and you'll have a little bit of fun with it too. And that time, in that case that I had where we actually did have to read everything into the record, my client and I, we were doing everything we could not to crack up laughing, because it was just such a fun experience, because we knew every single line that was read was just another nail in that coffin. If you have any questions about upcoming trial and how your evidence is going to come into play, or whether or not your evidence is going to be relevant or helpful or useful, call us. I'm more than happy to sit down with you. We'll go over what you've got, and we'll make sure that we are fully prepared for court. My name is Carl Birkhead. I'm with Wirth Law Office, and I want to help you make law easy.